Welcome back to the Money Mastery Unleashed podcast. Adam Olson with you here today, and I got a special guest with me, Alissa. How are you today?
Good, Adam. Thanks for having me.
Yeah, thanks for taking some time to join us. And I'm going to link all of Alyssa's information in the notes. And so you'll have her website and contact information if you guys have questions after the episode. So Alyssa's an attorney that we work with. And so we actually have an attorney with you, somebody that's not giving you suggestions that's not an attorney. So I'm really excited for today's episode. Alyssa, can you give me just a brief background about, like, let's say where you went to school and where you're practicing at right now and some areas that you focus in?
Sure. So I grew up in Creighton, Nebraska, and after that, I went to UNL for my undergraduate degree, and I got my I got my degree in agricultural economics, and then I went to UNL Law School, and that's where I got my law degree. After I graduated from law school, I went to O'Neill and practiced at a firm there. And then after practicing for a firm there for a couple of years, then I partnered with two other attorneys and we formed our own law firm. We have offices in Laurel, Norfolk, and O'Neill, and our firm's called Gallion Betcher Baier Law Group. And so we have the three partners and another attorney at our firm. One of my areas of specialty is the estate planning. I enjoy helping families and individuals with the passing on of their assets, whether that be while they're alive and after they've passed away. And then I also practice in some other areas, including real estate transactions, as well as civil litigation and business entity formation.
Nice. So like you do the 1031 exchanges and say LLC partnership formation and those kind of things as well, right?
Correct. Yeah. hmm
Awesome. Awesome. And not just in Nebraska.
Yes, so I am licensed in South Dakota as well.
Yeah, awesome.
hmm
Awesome. Again, thanks for taking some time to do this. I know you're busy and I know your time is valuable to you, so thanks for doing
Sure.
this. So what I want to focus on today is to talk about estate planning, right? We're going to talk about wills, trust, how maybe some asset protection stuff we'll get into. And I would say that a blanket statement here, but everybody in some way, shape, or form needs to have an estate plan done. Would you agree with me?
I would 100% agree with that statement. Whether you are 18 years old and you're single, you don't have a lot of assets, it's a good idea to have an estate plan. It doesn't matter what stage of life you're in, whether you're single, married, what your age is, if you have children, if you don't have children, you need an estate plan.
Yeah. So I'm just like a general consumer here. If I hear the word estate plan, it seems like this grandiose thing that's super complicated, super expensive, and it's beyond my reach, right? But can you break it down for us really simple? What would you say an estate plan is? What is it and what does it accomplish?
Yep. So estate planning is the process of distributing and making decisions for your assets in your estate while you're still alive, along with when you pass away. So there's different things you can do. There's a will, you can do power of attorney documents and trust. There's payable on death designations. There's a number of estate planning tools that we can use to accomplish your goals in estate planning. And depending on the complexity of your situation or the amount of assets you have, if you have children, once again, that stage of life kind of plays on how complex your estate plan can be. It can be very simple, it could be a couple page will, or it can be more complex just depending on what your wishes and circumstances are.
Yeah, it just helps people, it helps the decide what goes where, whether you're here or not here, correct?
Correct. Yeah.
Yeah. And if you don't have this document in place, right? Is it a safe assumption to say that the state dictates what happens?
Yes. So if you die without an estate plan, then it just depends once again if you have children, if you're married, or if your parents are alive. So if you pass away and you're not married, then your estate and you don't have kids, your estate goes to your parents. If your parents are no longer alive, then it goes to your siblings if you have siblings. If you're married and you don't have children and your parents are still alive, then it goes, the first 100,000 goes to your surviving spouse, and then the next half goes to the surviving spouse, and the other remaining half goes to your parents. If you
Yeah.
pass away and you're married with children and you don't have an estate plan, then the first 100,000 goes to the spouse, and then the next is divided half to the spouse and half to your children. And then if you
Yeah.
pass, and it goes on and on, just depending
Yeah.
on your
Yeah. Yeah.
circumstances. It's called the laws of intestacy, is what would control if you do not have an estate plan.
So, like, let's say the half that goes to the kids and their minor kids, Alyssa, does
Sure.
the take me, for example, married, 4 kids, okay? And I
Mm-hmm.
don't have my estate plan done. Adam passes away, and the kids get in assets in some way, shape, or form. Does my wife Katie still make decisions on those assets then?
Sure. So the laws of intestacy, they do not take into account guardianships or trustees for any assets that are going to your children or who's taking care of your children at that time if you would pass away or if both you and your spouse would pass away and it's going to your kids. So say, Adam, you pass away, you don't have an estate plan, your wife Katie gets your first $100,000 worth of assets, and then the remaining assets are split. She gets half of them, and then your children would get the other half. If you don't have an estate plan in place that says, okay, Katie's going to be the trustee of those assets for the kids until they reach a certain age, then she would have to go through the court system, depending on the amount of assets that are going to the kids, and be appointed as the guardian over those assets or the conservator over those assets.
Which is a process that involves, I would assume, some court time, some legal fees. It's a little arduous, I would assume.
Saving money in the long run
Yeah.
by doing an estate planning up front versus, oh, well, happens to me, then they'll take care of it on the back end. And then it's also saving for your spouse. They're already grieving you that you've passed
Yeah.
away. And that's
Yes.
just another extra thing that they're going to have to do and go through, spend time and money on in order to get your affairs in place.
Yeah. And I was just thinking, I was like, man, if my kids got money, like my oldest is going to buy like every Lego set known to man. He's 7 years old, loves Legos. And
Sure.
then my middle one, he's going to go crazy on like Jordan gear. He loves Michael Jordan stuff. So, but that goes back to the importance of why it's important to have these documents in place. It's nothing crazy to do to get a will together. Say you're working with somebody like me and my family. It's not a crazy long, expensive process.
Correct. So it's a fairly simple. Essentially, I usually have an initial meeting with the clients. I get their information, what they have and then as far as what their plan of distribution is. After that meeting, I prepare drafts of the estate plan documents, the wills, power of attorney documents, medical declarations, and I think we'll get to that a little bit later
Yep.
in the
Yep.
podcast, what that entails. But as far as that, and then I send them the drafts, they review the drafts. If everything looks good, if they have questions, changes, they let me know. And then we schedule a follow-up meeting where they would sign those documents. So
Yeah.
essentially, you're meeting twice with an attorney. If you want to do a phone conference, I know a lot of attorneys will do initial meetings, can be phone conferences. That's an option too.
Yeah. That's awesome. So I love what you said there. The first meeting you talk about goals, right? That's the
Yes.
next thing that I wanted to talk about here. And so when I'm having these conversations with clients or we're doing financial planning things, first we got to gather everything you have, and then we have a goals conversation. What are we trying to accomplish? And some of the things I would assume that some people are trying to accomplish when they're working with an attorney on their estate plan, deciding how assets transition, when they transition, is things such as asset protection. Maybe it's minimizing taxes. Maybe it's caring for like a special needs child, caring for minors. Can you talk about some of the goals that clients have, maybe the most common ones when they come in to work on their estate plan needs?
Sure. And once again, that just kind of depends on what stage of life you're in. So
Yep.
if you're newly married and you have children, one of the primary goals would be we want to make sure our children are taken care of and provided for in the event something happens to both of us. So in that instance, they would want to list a guardian. So that's the person who takes care of their children. Physically, that's where they are going to be cared for, and then who's going to be looking over the assets until the kids reach a certain age can get that outright. Now, if you have an older couple come in, one of their primary goals would be we want to make sure to protect our assets from the nursing home. Is there anything we can do to do that? Is there something we can do to minimize estate and inheritance tax? And then another thing that I see, it doesn't matter what the age of the client is, one of their primary goals is to just minimize any family conflicts in the future and make sure that you preserve that family harmony within the family.
Yeah, I love that, Alyssa. I always say these are never fun conversations to have. Like, hey, Adam and Katie die. Who's taking care of our kids? Adam and Katie die. Who's taking care of the money for the kids? Those are tough conversations. They're not fun having. But if we don't have those conversations and have a plan in place now, how much more difficult is that when we're gone? So can you say us, take us for example. Say we don't have an estate plan in place. I don't have my wills done. I don't have power of attorneys done. I have nothing done. What happens if I have a dad pass away and they have minor kids? What happens?
Sure. And that is your wife still alive? Or
Both passed away.
both pass away. So if both of you pass away, there's minor children, then if you don't have an estate plan, you don't have a guardian named as who you would want to take care of your children,
Yep.
then you could have your family, you could have your siblings or parents, and then Katie's siblings or parents, they could fight to say, okay, well, we want to be the ones that are taking care of the younger kids. We want to be the ones controlling the assets. So then there's a lengthy drawn out court process, which then could become contested because both of your families have no idea what your wishes were as far as this is who we want to take care of the kids. This is who we want to take care of our assets until the kids reach a certain age.
Yeah, yeah. And or maybe you have naughty kids and nobody wants to take care of them.
Yeah, well, hopefully that doesn't happen. Hopefully the Department of Health and Human Services doesn't have to step in at that point, but
But that probably does happen, right? If nobody wants to take the kids, aren't they become like state, right?
yeah, they could become wards of the
Yeah.
state and then they would be placed with foster families and then eventually they would be adopted or there would be a guardianship.
Yeah, that's not fun to think about. I mean, if you have kids,
No,
I mean, my big takeaway from this whole thing today is if you have kids, please, please, please get something done and in writing.
exactly. And that's what people come to me and they say, well, we're just doing this because someone told us to do this because we don't have a lot of assets, but we have young children. And that is why it's so important to come and get your estate plan done. Even if you don't have a lot of assets now, if you have kids, you want to make sure your kids are taken care of in the event something happens to you and your spouse.
Yeah, that's awesome. And so that would just be some basic advice. If you have kids, get it done, right? And I have a lot of people that say, hey, I'm just going to go online to this website and do it. Like whatever, LegalZoom or whatever websites are out there just to do it online. And I always suggest that they work with like an attorney that's licensed in the state. So as an attorney, can you tell me why it's not generally not a good idea to use online stuff versus somebody who's like you?
Sure. So you kind of hit the nail on the head where you want to go to an attorney that's licensed in that state where you need to get your estate plan done because LegalZoom, they might have a generic will form or estate planning form for you to fill out, but does that comply with your state's laws? So for instance, Nebraska law requires two witnesses to sign off on your will. If you're so I had someone come in here the other day and someone had their uncle had passed away. They said, "Oh, he did his will online. Here it is." And they just had a notary sign off on it. And that is not valid in Nebraska because two witnesses didn't sign off on it. They didn't know that. They thought, oh, I'm getting a good deal. I'm going to LegalZoom. I'm only paying much money to get this document. But in the long run, it's costing them more money because it's a nightmare now because, okay, all the beneficiaries have to agree and do a family settlement agreement that this will is going to be valid. If they don't all agree, then it passes by those laws of intestacy that we talked about earlier.
Yeah. Which can get dragged out in court for God knows how long.
Sure, exactly.
Yeah. I mean, I always tell people when, they hear, hey, I found it online for free. Well, I mean, a piece of paper. I mean, like, come on, guys, like, think a little bit here. Like, use somebody that's comfortable and get it done the right way, right?
Correct. So that's the thing is that you might be saving money up front, but in the long run, you're doing yourself a disservice and your beneficiaries a disservice because they're going to have to spend more money in the long run.
Yeah, thank you. Thank you for that. Let's talk about like some components of the estate plan, right? And so you already talked about will dictates who gets what, right? You already said
Sure.
that.
Mm-hmm.
Let's talk a little bit more about some other things. Like maybe can we get into some trust talk here? Can you talk briefly about some power of attorneys, maybe and beneficiary directives? I'd like to hit on those. Let's start with the beneficiary. So in my world, working with say life insurance contracts or investment contracts, most times we name individuals as beneficiaries. Can you talk about times with beneficiary designations where that's appropriate or not appropriate?
Sure. So with a payable on death or transferable on death designation, that trumps what's ever in your will or in your estate plan. So if I have a payable on death designation on my bank account to my husband, but then in my will I say I want it to go to my son, it whatever the payable on death designation trumps what's in my will, so it would go to my husband rather than what my estate planning documents say. So with that, you can name individuals there, you can name charities, you can name trust. And I don't know if we want to dive into trust now, but that's what
Yeah.
the payable on death and transferable on death, that trumps what's ever in your estate planning documents, and it automatically goes to whoever you have named. Those assets, though, that have payable on death beneficiaries, except for life insurance proceeds, those would be subject to inheritance tax, which
Yep.
we'll get to that in a little bit.
Yep. Yep. That's
Mhm.
awesome. Yeah, and that's a perfect segue into trust. So let's talk a little bit about trust, maybe from an asset protection tool and a transition tool, if you don't mind.
Sure. So, as far as trust, there are several different kinds of trust. There's what's called inter vivos trust. That's just a fancy term for saying a living trust. So, that's established during your lifetime. Those can be
Yep.
revocable, meaning they can be changed at any time, or there's different circumstances where you might want to look at doing an irrevocable trust, which that can't be changed. You can do a testamentary trust, which that's essentially established upon your death. So within your will, you could say, I want a children's trust saying that if something happens to me, my assets are going to my children within this trust. Within that trust, you designate this is the age I want the kids to get the assets outright. While it's in the trust, you name a trustee
Yep.
and say the trustee has discretion to give the kids money for health, education, maintenance, support until they reach that certain age, and then they would get it outright.
Yep. So this testamentary trust, would you say that'd be like a common tool that's used for younger people? Maybe they don't have a lot of assets now, but they have these large life insurance policies. And if something happens to them, that testamentary trust is set up when they pass away. Trustee manages the assets for the kids. Is that a time when that's used?
Yes, that would be in a very appropriate time, would be where there's large amounts of money coming from the proceeds of a life insurance. You would want to name that trust as the beneficiary of that life insurance policy. So it funnels into the trust and it just doesn't go outright to your kids.
Yep. And there's a lot of coffee shop talk that I would say that happens around this quote unquote trust thing. And so like I think a lot of people think that let's take the married couple that's 50, 60, 70. Let's say they have a large estate. What
Okay.
they have investments, they have physical assets, say farm ground, rental properties. They have a larger estate. And sometimes people think with trust is that, hey, I just put all my assets in a trust. The nursing home can't touch them, Medicaid can't touch them. And guess what? I think my kids get it all income tax free too. They never have to pay a penny on tax. That's not really how trusts work. But can you kind of let's dig into a little bit and explain when is appropriate time for you to use those trusts that you just mentioned at the start here?
Sure. So you are correct that that is just coffee shop talk, and you can't believe
Hmm.
everything you hear at the coffee shop. Because a lot of people do come to me, and initially they say, "Oh, I want to create a trust to put all my assets in to protect it from the nursing home or any creditors down the road." That's simply not true. You can't really put your assets into a trust, and they are not going to be subject to the nursing home Medicaid down the road.
Yeah.
So, but it would be appropriate to set up a trust for a married couple that's 50, 60, have some farm ground, have a business, whatnot. Within that trust, you can put certain terms as far as saying, okay, the land in this trust is going to go to all of our kids, but then there's going to be a right of first refusal or an option to purchase within that trust that outlines the terms, saying that if someone wants to sell their interest in the real estate, they have to offer it to their siblings first at these terms. Or there's the option to purchase that I was talking about, and that would be as far as if the on-farm heir or the someone who's taking over the family business wants to buy out their other siblings, they're able to do that within a certain time period and then on these certain terms there. So it's very beneficial to have a trust for if you do have that real estate, if you have a family business, just to pass it on down to the next generation, which that is another primary goal of people that own the farm ground, own businesses, that we want to make sure that there's a smooth transition to the next generation and they can continue that farm or that business.
And it puts guardrails on what can be done, right?
Correct. Yep. So then
Which is a good thing.
there can't be a forced sale at any time.
Yeah, which is a good thing.
And then to answer your question, I think you had asked regarding like as far as taxes, they won't have to pay tax on this or anything. So anything that would be in the trust is still subject to inheritance tax and estate tax.
Yep. You can't escape those.
No, unless you're gifting it outright.
Correct. And that's what I wanted to talk to you about next. I've had a couple situations where assets have been inherited and, for whatever was done, an irrevocable trust or the asset was gifted, the beneficiaries, Alissa, didn't get that step up in basis, right?
Correct.
So I got to say, let's talk farm ground, for example. Say dad bought this farm ground in 1920 for $10 an acre or something. And now this farm ground is worth $10,000 an acre. And son inherited the ground 15 years ago. And for some reason, they want to sell the ground now. Well, they have this massive tax due between the $10 and $10,000 because they didn't get step up in basis because of an irrevocable trust or the asset was gifted or something along those lines. Do you have any situations like that where you might not suggest that is done, whereas the step up in basis and actually paying some inheritance tax is a good thing because you do get that step up in basis by holding on to the asset till your death?
Sure. So I just met with a family before now, and they said they had that exact question. They said, "Oh, we're thinking about gifting all of our
Yeah.
real estate now. What are some of the tax implications of that? Would there be any consequences? Because we don't want our kids to have to pay that inheritance tax." So with that, if you gift assets, who's ever getting the asset gets the carryover basis, meaning whatever basis that you have in the property when you bought it or you inherited it. So where you said if you bought it for a couple $100 an acre several years ago, and now it's worth the $10,000 an acre, if you gift that real estate, the basis in the real estate remains at that couple $100 an acre. So then if you turn around and sell it, they're going to have to pay capital gains tax on the difference from the amount they sell it for versus what their basis is in it. So you're going to get nailed with that capital gains tax, but you get a step up in basis if you inherit it. So if you get it once someone passes away, then the basis steps up to whatever fair market value is upon the date of their death. So then if you turn around and sell it at that point, you're minimizing your capital gains tax you would have to pay because they got that step up in basis.
Yeah, I think of that as like they're trying to save $1 today, but it's going to cost their beneficiaries $20 down the road. You know what I mean?
Yep.
So like, Alissa, why is it that why do they look at that as an option? Are they like scared of losing it to the nursing home? Why do most people look at that as an option?
Yep. So one of them is because they're scared of losing it to the nursing home. So if you gift real estate and get past a 5-year look back period, the nursing home cannot come after those assets. or you can use what's called a life estate deed, where you're deeding the real estate to your beneficiaries, but you're retaining and reserving that life estate, meaning that during your lifetime, you get the full use, income, control, possession of the real estate. And when you die, it automatically passes to the beneficiaries you have named. If you get past a 5-year look back period from the time that you record that life estate deed to the time you would apply for Medicaid at the nursing home, they cannot force the sale of that real estate to pay for your care. They can come after the income off of it, but they
But not.
couldn't ever force that.
Yeah.
So yep. So that's I guess one of the situations where people come in and say, well, we're looking at gifting because we want to protect it from the nursing home. Another
I get,
situation would be, well, this son or daughter is farming, so we want to make sure that they're able to continue farming and don't have to worry about the other siblings.
yeah. That life estate deed, how does basis work in that though?
So you get a step up in basis. So
You do.
when they pass
Yeah.
away, you still get the step up in basis. And you
Yeah.
still have to pay that inheritance tax on that though
Yeah.
too.
Are those pretty common that you're doing a lot of life estate deeds as well?
Yes, those are very common.
Yeah. How about like say you got the average mom and dad retirement assets and they got the house. What are some
Sure.
common things that people do with their house as far as we're looking from a protection standpoint or a transition standpoint?
From a transition standpoint, if they don't want to do a life estate deed, because with that life estate deed, even though you have the life estate interest, if you ever decide you want to sell your house, if you want to borrow against it, it requires all of those remainder beneficiaries and their spouses to sign off on it. So they might say, well, we're probably going to sell our house down the road, so we don't want to do that route. Another route would be a transfer on death deed. So with the transfer on death deed, that essentially says when you pass away, it goes to these beneficiaries named. Those can be revoked at any time. And with that, that avoids probate too. So if you have this transfer on death deed, when a person passes away, you file the death certificate against the real estate, it automatically goes to the beneficiaries listed, and there's no need for a probate, just depending on how your other assets are titled too.
Yeah, I would say that's a pretty common thing that should be done for a lot of older couples, isn't it? Just that transfer on death deed with the personal
Yes. Yeah.
residence. Yeah, very
Yeah.
common. Right?
Yeah, I would say so. And two, it just kind of depends to what your situation is. I always tell clients there is no cookie cutter approach to estate planning. So that's another reason why not to
Yeah.
use those legal Zooms or online
Yeah.
platforms to do your estate planning, because everyone's situation and circumstances are different. So in some instances, yeah, that transfer on death deed would make sense for someone to do.
Yeah, I mean, you're so spot on when you say that. It's just like in the financial planning world that everybody's plan is different. I always tell people it's like my kids. Their personalities are different, right? I have to holler at my older kid to get his attention, but my middle one, if I holler at him, he'll go cry in the corner for a half hour because their personalities are just so different. Well, that's like everybody's financial plan or estate plan. Everybody's needs are so unique and different that it has to be individualized.
Yes, exactly. And those things change down the road
Yeah.
too. So that's the other thing is circumstances change. Children, your kids could pass away and something unexpected could happen, divorces, anything like that. So it's not a one-time deal to get your estate plan done. You have to make sure that you review it regularly, especially if your circumstances do change and your wishes change. You want to make sure that you update that. And most
Yeah.
all of the estate plan documents that you do can be amended or changed at any time, unless you're doing something like an irrevocable trust.
Gotcha. Gotcha. So how often, say families, every time we have a kid, should we be updating our will?
You not necessarily. So
Okay.
I typically include a provision within a will or a trust that says my children are, list your kids, and then I say any future children born to
Yeah.
us would be included in this provision. So you don't necessarily need to change it every time you have a child.
Yeah. Let's talk about the estate tax. Is that okay if we move on to that for a few minutes?
Yeah, fun topic.
Yeah. And so that irrevocable trust that I told you about that the client didn't get the step up in basis, it's because that irrevocable trust was done years and years ago because parents were worried about the estate tax limit. Well,
Mhm.
that's always changing. That's always a hot topic, political. What's the estate tax? What is it? What's the
Sure.
tax? And what are some limits that people need to be aware of?
Yep. So first we'll talk about that federal estate tax and then we'll talk about Nebraska inheritance tax. But the
Yep.
current federal estate tax is at $13.61 million per person. So that means that if your amount of assets are underneath that $13.61 million, you will not owe any estate tax. If you're over the exemption amount, then that's where you would owe estate tax, and that estate tax rate is very hefty. It's 40%. So with that though, that's like you had mentioned, it's always subject to change. So the current exemption levels are very high, but they are set to sunset in 2026, and the exemption is going to fall down to $7 million per person. But politics are at play here.
Yeah.
We don't know what's going to happen.
Yeah.
So there's a bunch of different things that could happen. We could have them stay high, they could go lower. We don't know. And if you are married, there's a concept called portability where you have your federal estate tax exemption of one spouse, which would be the 13.16 right now, or 13.61 right now. If I passed away, my exemption amount could be ported to my husband. So if I pass away, the exemption's the $13 million. My husband gets my $13 million exemption. And then when he passes away, whatever exemption, the exemption limit is that time, he gets that as well.
Yeah. He gets both, right?
Yes.
Yep.
Mm-hmm.
Yep. So it is, I mean, those limits are fairly high right now, historically speaking, right?
Correct.
Yeah. I mean, and if it's, if that comes down to say $1 million, I mean, that encompasses a lot of people. That's like a quarter of ground right now.
Correct.
That affects a lot of people.
Yep. So there's some planning that you want to take into consideration. That would be one of your considerations when you're doing estate planning, is to say, okay, am I worried about that federal estate tax exemption? And you hit the nail on the head too, where land prices right now are very high. So it doesn't take a lot of ground to be close to that high exemption amount.
Yeah, it's kind of crazy actually. Um, and so then not only do we have the federal estate tax, but talk about our wonderful Nebraska.
Yes, so Nebraska is currently one of 6 states that has inheritance tax. Soon we will be only one of 5 because Iowa is actually phasing out their inheritance
Yeah.
tax. So if you die and you live in Nebraska when you pass away, then your beneficiaries have to pay inheritance tax on the assets that they receive. So if it's going to a spouse, spouses are exempt. If it's going to a class 1 beneficiary, which that's considered your kids, grandkids, parents, siblings, each of them get a $100,000 exemption. Anything they inherit over 100,000 is taxed at 1%. If they're a class 2 beneficiary, so say I'm leaving my estate to my nieces and nephews, aunts, uncles, cousins, they're more remote relatives, that would be considered a class 2 beneficiary. They get a $40,000 exemption. Anything that they inherit over 40,000 is taxed at 11%. So
Yeah.
that it gets pretty hefty. And then if they're not related to you at all, so this would include like longtime significant other. So say you've dated someone for like several years, never been married, they would be considered a class 3 beneficiary, or the neighbor, whoever, just not related to you. They only get a $25,000 exemption. Anything they inherit over that is taxed at 15%. So that's pretty hefty tax there. And then
Yeah.
the other thing, those rates are actually in the amounts they changed in 2023. So before, those levels used to be even worse, if you can believe that. And then they also changed in 2023 that if you inherit assets and you're 22 years old or younger, there's no inheritance tax imposed.
Interesting. Doesn't matter your relation to the
Correct. Yep.
interesting. Okay.
Mhm.
Okay. What has there been any legislation? You just said it changed in 23. Have they looked at like getting rid of that or lowering it even more?
Yes, so there was actually some legislation introduced this current legislative session to repeal Nebraska inheritance tax or put it on as on the ballot for the voters to decide that, and it did not gain much traction. So there is talk about it being repealed or phased out like they did in Iowa, but right now we still have that inheritance tax.
That's kind of like our property tax 50% reduction that didn't really go too far.
Exactly. So that's what I always say. I was like, well, they're trying to reduce property tax on one hand, so they can't probably get rid of inheritance tax over here because they'd lose another revenue source. So
Yeah,
it's you pick which one you want to go for.
yeah, pick your poison, right?
Mhm.
The other thing that I talked to, so this podcast, I primarily gear it towards business owners in their middle years, 30s, 40s, 50s.
Sure.
And to like people that's our age, right? So for us,
Mhm.
this estate planning conversation, this estate tax thing, it seems far reaching, way out of grasp, something that I'm not going to have to worry about for 30 plus years. But can you talk to some of the things that you can do in your younger years to make the estate planning conversation easier or smoother in your 60s and 70s? Does that make sense what I'm asking?
Sure. So, what are some considerations that people should be thinking about now if they're like
Yeah.
middle-aged? And once again, it just depends too if they have children, if they don't have
Yeah.
children, if someone's going to be taking over the family business. So that's the why, I mean, there you can get an estate plan now, but Adam, your estate plan is going to change in
Hmm.
10 years down the road too.
Hmm.
So if one of your kids are going to be taking over your business, that plays into it as well, but you just want to make sure that right now, what I would say is, do you have those payable on death beneficiaries? Do you have the trust set up as far as your kids if something were to happen to you and
Yep.
Katie, the guardians listed, things like that? And as far as transitioning like a business or a farm to the next generation, it's hard to make decisions regarding that if you are middle aged because you don't know
Yeah.
if which kid is going to be coming back to the business or to the farm. So you might have a more simple, not as complex estate plan when you are middle aged. But then when you get a little bit older and you say, okay, I know this child is going to be coming back to the family business, the family farm, that's when you need to make sure that you're updating your estate plan at that point.
Yeah. I love that. I always encourage people to work with professionals that are going to see them to and through what they're trying to accomplish, right? So, young people like us that are professionals, I always say, if you're 55 or 65 and you're going to an estate planning attorney that's 75 years old, they're probably not going to be around to help you with future changes. And so I always say the benefit of working with a firm that has younger professionals, that's a firm that it's more than just one person, is I'm working with you. My plan changes in 5 years, changes in 10 years. I can go back to that same young professional. They're still in the business, they're familiar with my plan, and we can update things as I'm proceeding through life versus, yeah, I did this 10 years ago, the guy's no longer around. And then you just repeat that cycle. It's a lot harder. It's a lot harder to update things versus if you're working with somebody who can grow through your financial life, through your estate planning needs with you. That's just I can't stress to people enough how important that is.
Sure. And you want to work with someone that obviously younger people are great to work with too, that you feel comfortable with. And if you are working with an older attorney or whatnot, you want to make sure that, okay, if they're a solar practitioner, what is their succession plan in the
Yeah.
events when they retire or something happens to them? Who's taking over their files? So that's why I enjoy being a part of a firm because if something were to happen to me, I have other attorneys in my firm who would be able to pick up where I left off.
Yeah, but I think a lot of people don't think about that, right? It's great that you did something, right? That's awesome that you
Mhm.
have your documents in place, but what happens when you pass? So like that's something I always talk to Katie about and or clients about is, hey, what happens if something happens? What do you do? Well, you go to the firm that has everything for you. Like you come to us for all of your financial needs because we have all your financial needs handled in house.
Sure.
The same thing with your attorney. You go to them for everything because they have everything in house and it's an established firm that's been around.
Sure.
I just can't stress how important that is.
And you want a good group of advisors that you can count on,
Yeah.
or that someone, when you do pass away, make sure your beneficiary, your spouse, your kids know who those group of advisors are. And so they can go to them, and it just makes that a lot easier as to what are the next steps are. So, as far as a group of advisors for your estate planning purposes, you find an attorney. We also rope in your financial advisor, your loan officer, your accountant
CPA.
who's
Yeah.
preparing your taxes. And we want to make sure everyone's on the same page and understands, okay, if something were to happen to you, this is what's going to play out.
Yeah, yeah, that's awesome. The last thing I want to ask you on is the LLCs. So, and I want to talk about it from an asset protection standpoint, right? Do you, is it a blanket suggestion that if you own property, rental property, that it should be in an LLC?
So it's a good idea to look
And why,
into
I guess.
it. Yep, to look into an LLC, a limited liability company, if you do have a rental property or a business, because if, say, so your rental properties are in that LLC, something happens to that rental property, someone's suing you, and if your insurance doesn't cover it, they can only go after what's inside the LLC and not after your personal assets, your retirement accounts, your bank accounts, if you have other farm ground. So that's why it's a good idea to look into doing an LLC if you do have a business, rental properties, just to afford yourself protection in the event, worst case scenario, something happens and someone's suing you.
Yeah, yeah, it's peace of mind, I guess. Say it that way, peace of mind.
Sure. And
So
that
let's
could
just,
be a whole nother
yeah,
podcast
yeah, 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 yeah.
session as far as the entities there and reasons why to do certain ones and why you need it, entities.
Yeah. Um, I guess in closing here, thank you for your time. I know it's valuable again, but is there any other closing thoughts when we're talking about estate planning, securing your legacy? Is there any closing thoughts or any takeaways that you have that you wanted to share that we haven't hit on yet?
Sure. So we didn't get into power of attorney documents.
Yes, yes,
So
yes, yes, yes. Yes, very
yes,
important.
so power of attorneys are while you're still alive, who's making decisions for you. So there's a financial durable power of attorney. So that's who makes the business decisions for you, signs off on checks, bills, taxes, gets your mail in the event you're not able to yourself. And then there's also the healthcare power of attorney who makes medical decisions for you in the event you're not able to make your own medical decisions. The reasons why those are very important, they're just as important as a will or a trust, is that if you were to get into a car accident, you become incapacitated, you're not able to do those things for yourself, but you're still alive, who's doing that for you? And if you don't have those power of attorney documents, then you have to go through the court process and get a guardian and conservator appointed to be making those decisions for you, to be handling your business, handling your finances.
Yeah, so just because somebody's married, that automatically does not make them your default power of attorney, correct?
You are correct. Yep.
Yeah,
So they would have to still go through that same court
yeah,
process and get a guardian or conservator appointed to act on your behalf. So, and
yeah,
it's a lot cheaper just to get the power of attorneys done right off rather than have to go through that guardianship conservatorship
yeah.
process.
I mean, I've heard horror stories of like incidents at the hospital or medical facilities because of that. Um, Financial, like bank accounts, brokerage accounts. Like, if you don't have that power of attorney, I don't care if it's your spouse of 45 years. Like, there's certain things you cannot do if your name's not on that account or you don't have power of attorney, right?
Correct. Yeah. So if I have
Yeah.
accounts with you, Adam, and my husband's name is not on that account and he does not have my power of attorney, if he calls you up and he says, Adam, I'd like to withdraw those funds from Alyssa's account, what are you going to tell him?
See ya.
Yeah, you
Show me the
can't do
paperwork.
that.
Yeah, show me the paperwork. Yeah, we got to see it. Yeah, it's something that a lot of people don't think about. You don't think about it till you're right in the middle of it, and then it's too late.
Exactly. And then that makes it harder on your loved ones when they're having to deal with medical issues is that, hey, we got to go through this court process over here because we didn't have the correct paperwork done to
Yeah.
prepare in case something like this happened. And another document too that I wanted to bring up, and I know we're running out of time
No,
here,
no, you're good. We're
but
good.
would be the medical declaration. That's also
Yeah.
known as a living will. What that says is that if you were to lapse in a persistent vegetative state, the doctor says there's absolutely no chance of recovery, that either you want to be hooked up to life sustaining treatments or you want those life sustaining treatments withdrawn. The reason why that document is so important is because once again, it makes it easier on your loved ones. They don't have to make that decision for you. They already know, they know that, okay, Alissa wanted me to just essentially pull the plug. I know that sounds morbid and
Yeah.
terrible, but then it just makes it easier for them and they say, well, that gives me peace of mind. That's what she wanted.
Yeah. And those are like the will, power of attorneys, and this last one. Those are all basic things that like people set up right away, right?
Correct. Yep.
Yeah.
Yep. And then if your circumstances change or the person you designate as that power of attorney, if something happens to them or you want to change that, you can change that at any time.
Yeah. Yeah. Just a stroke of a pen, right?
Correct. Yep.
And two
But you want to
witnesses.
make sure it's done
Yeah.
correctly. So you're once again going to the attorney to make sure those documents are done correctly.
Yeah. This has been awesome. I think this is really beneficial because we talked about everything from young families, what they can do. And then we went to, older couples, what they can do from an asset protection and preservation standpoint. And then we hit on some very important documents that people have in place. And I think it's extremely important too that it's not a one and done deal. Like this isn't something you do once and then you never revisit it again, right? It's something
Correct.
that needs to be revisited and updated as your life changes. I think that's very important to take away as well.
Yes, definitely agree with that. And then your estate planning goals will probably change throughout your lifetime as well. So that would be a good starting point is to write down your estate planning goals, where you're
Yep.
at in this stage of life. What are your goals? Once you figure out what your goals are, then schedule that appointment with your advisors, with the attorney and say, these are my goals. This is what I want to happen. What are my options?
Yeah. And I love the team approach that you talked about too. That's very important from our standpoint too, and something that we love to do as well.
Mhm.
Awesome. Well, I'm going to share your contact information. It's all going to be in the notes, Alissa. Thank you again so much for taking the time to do this. I really appreciate it. And I know this episode was very beneficial to me, and I know it's going to help a lot of people that listen to this episode as well. So thank you again.
Yeah, great. And thanks for having me. And yes, feel free to reach out if you have questions about estate planning. And I should have prefaced this at the beginning of the podcast,
No.
but this is not legal advice.
Yeah.
It was just for educational purposes only. So
Yeah. Don't worry. I got a blanket disclosure that'll blanket the episode notes, and they play it at the end too. So we hit them from all sides.
perfect.
Got to make sure to get that in.
Yes.
I'm just going to stop the Investing involves risk, including the possible loss of principal. Past performance does not guarantee future results. Diversification does not guarantee a profit or protection lost against loss in a declining market. Purchase of life insurance is subject to meeting underwriting requirements. There is no guarantee of an individual will be insured. Annuities are long-term investments designed for retirement purposes. Withdrawals of taxable amounts are subject to income tax, and if taken prior to 59 and a half, a 10% federal penalty tax may apply. Guarantees are backed by the claims paying ability of the issuer and are subject to their terms and conditions.